Here's a great question. Rule 11. What is it? Sometimes we lawyers forget that not everybody knows what it is. All state and federal rules of procedure have a rule similar to this. This is Nevada's version. First, it requires that every pleading, motion, or other paper filed with the court must be signed by at least one lawyer representing that party. By signing it, the lawyers represent that it is not being presented for any improper purpose, such as to harass, cause delay, or increase the cost of litigation. The claims, defenses, or other contentions must be warranted by existing law or a non-frivolous argument to extend the law. The factual contentions must have evidentiary support, and denials of factual contentions must be warranted on the evidence. If, after notice and reasonable opportunity to respond, a court determines that the rule has been violated, the court may impose an appropriate sanction on any attorney, law firm, or other party that violated the rule. A motion for sanctions can come from the other party, or the court can do it itself without a motion from the other party. Sanction can include non-monetary directives in order to pay a penalty into court, or in order to pay the other side's attorney's fees.
Hey, my trendies, trendsetters, and my trendy tribe. I would like to read some Alabama criminal laws that may apply where they may apply. So, shout out to the trendy that sent me this. I'll just say that. Here we go. Section 13A-10-131, simulating legal process. A person commits the crime of simulating legal process if he knowingly delivers or causes to be delivered to another person any demand, request, or claim for the payment of money or the delivery of transfer of property that in form and substance simulates any legal process issued by any court of the state. Simulating legal process is a Class B misdemeanor. Section 13A-10-132, crimes in connection with sham legal process, etc. It shall be unlawful for a person to impersonate a state or local official or employee or a law enforcement officer in connection with a sham legal process by acting or purporting to act in an official capacity or taking advantage of such actual or purported capacity by either of the following: subjecting another person to arrest, detention, search, seizure, mistreatment, dispossession, assessment, lien, or other infringement of personal or property rights, denying or impeding another person in the exercise or enjoyment of any right, privilege, power, or immunity. A person violating subsection B is guilty of a Class B misdemeanor. It shall be unlawful for a person falsely to assert authority of state law in connection with the sham legal process. A person violating this subsection is guilty of a Class A misdemeanor. It shall be unlawful for a person to knowingly act without authority under state law as any judge, magistrate, hearing officer, juror, a clerk of court, a commissioned notary public, or any other official authorized to determine a controversy or adjudicate the rights or interests of others, or to sign a document as if authorized by state law. A person violating this subsection is guilty of a Class A misdemeanor. It shall be unlawful for a person to falsely assert authority of law in an attempt to intimidate or hinder a state or local official or employee or a law enforcement officer in the discharge of official duties by means of threats, harassment, physical abuse, or use of a sham legal process. A person violating this subsection is guilty of a Class C felony. Section 34-3-87, other causes of removal or suspension. For the following causes, an attorney may be removed or suspended by the circuit court: upon its being shown to the satisfaction of the court that he or she has been guilty of any deceit or willful misconduct in his or her profession; for a willful disobedience or violation of the order of a court requiring him or her to do or forbear an act connected with or in the course of his profession; for a willful violation of any provisions of Section 34-3-20 or Section 34-3-24. Section 34-3-89, who may initiate proceedings. The proceedings to remove or suspend an attorney, as provided for in Sections 34-3-86 and 34-3-87, may be taken by the court on its own motion or upon the motion of any third party.
The whole purpose of Rule 11 is to stop lawyers from filing crappy lawsuits. A lawyer can be sanctioned if they file something with the court for an improper purpose. Lawyers have been sanctioned for filing lawsuits for retaliation, delaying the inevitable loss of one's home, or disrupting a disciplinary proceeding. Some folks should remember that courts can and will consider public statements, like at a press conference, when evaluating whether or not to impose sanctions. Also be sanctioned if you file lawsuit after lawsuit after lawsuit, even after the judge has told you that your lawsuit is a piece of shit. Did you know that judges can impose sanctions sua sponte? It's a fancy Latin phrase for without being asked. That means if the judge is so irked by, say, a fraud complaint based entirely on reckless allegations, that judge can impose sanctions even if no one has the balls to ask him to. Young lawyers, and some old ones, should keep in mind that cranky judges can impose sanctions for really bad writing and typos. So friends, if you know any lawyers who are filing really crappy lawsuits, send them this message. Rule 11 is coming.
It was funny to me, but she took it all serious and got in her feelings and got mad.
I've been taking my time